Marcus, my friend, the thing is, the numbers, they just aren't adding up, are they? Like, you pay your minimum payment, right, on time, and then next month, it's higher. And you've seen the headlines, haven't you? All this talk about the administration getting tough on something. But then, when you look at the statement, it's like those headlines never even existed. It's the same number, almost as if it didn't happen.
Yeah, Amara, it's really striking, isn't it? What does it actually mean? When a deadline that's like written into an executive order just passes. No document filed, no one in the building says anything about it. It's almost deafening, the silence when you're looking for that official paper trail.
Exactly. And we're not talking about some small thing here, are we? Executive Order 14365, December 11th, 2025. This thing has 5 separate tracks, Mark. 5. And 4 of those deadlines, they all landed on the same day, March 11th, 2026. That was like 7 weeks ago, right? And in those 7 weeks, the news cycle, it's been buzzing. We've had the National Policy Framework on AI, the Trump America AI Act discussion draft, the Guardrails Act, but none of them were the 4 deadlines we were actually expecting.
Marcus, that's such a keen insight, really. So we have these 4 absences then, and as you say, absences don't run on the show. That's the cover story, isn't it? But now tell me, what was actually supposed to be there? Like, who was supposed to do what?
Okay, so Howard Lutnick, the Secretary of Commerce, he was directed to publish by March 11 an evaluation of what they called onerous state AI laws. He was also, by the same date, to issue the Commerce Department's BEAD policy notice. That notice, Amara, that's the document that actually conditions roughly $42 billion in broadband funding on state compliance with federal AI policy. I mean, $42 billion? That's the kind of money that reorganizes a state legislature when it actually moves. But held in reserve, it reorganizes nothing. And the reserve itself, that's really the story.
42 billion? Wow, that's a staggering amount, isn't it? And if it's just sitting there, held in reserve, not doing its job, well, it really highlights your point about absences. What about, the other players? The FCC, the FTC, what were they meant to do?
Right, so then the FCC was directed, again by that same March 11 date, to initiate a proceeding on a federal AI reporting and disclosure standard. No proceeding initiated. The FTC, they were directed, again by that same date, to issue a policy statement on state law preemption. No policy statement issued. And there's one more, Amara, a bit outside that March 11 cluster, but definitely like in the same posture. The AI Litigation Task Force was established within the Department of Justice on January 9th of this year. As of this week, that's 110 days. 0 filings against any state AI law, including the one specifically named in the executive order, believe it or not.
Oh, tell me about that one, because I feel like I've heard it mentioned before. The one specifically named, you say?
Yeah, it's Colorado. The Colorado Artificial Intelligence Act. It takes operational effect June 30, 2026. That's 60 days from, where we're sitting right now. The federal preemption apparatus has had, depending on how you count it, between 90 and 140 days to produce binding action against it. And in that window, it's produced 4 missed deadlines and 110 days of task force inactivity. But get this, Amara, on the other side of the same building, the Office of Management and Budget Memo M26-04 issued December 11, the same day as the executive order. Russell Voigt, the OMB director. That memo set a compliance deadline of April 15th for federal high-impact AI systems. April 15th came, the compliance ran. So the executive branch can execute when it chooses to. What you're looking at here, it's not a capacity failure. It's a selection.
Selection. That's it, isn't it? The mechanism. Selective execution. Internal procurement compliance, that proceeds on schedule. But external preemption against state law? That's held. It's the same administration, the same memo date, the same authority, but different posture. different output. And the market, Marcus, the market knows. They really do.
Oh, absolutely. The market is always watching. It's the ultimate truth teller, isn't it?
It truly is. Kalshi, for example, has a contract, ticker WHAIEO, that resolves on whether an executive order containing AI safety standards is issued by June 1st, 2026. And as of this morning, that contract is trading at 62 cents. Now, the narrative implication of all this coverage volume we've talked about, the framework release, the discussion draft, the task force establishment, is something closer to 80 cents, right? That, my friend, is an 18-point gap. When a market with real money in it gives you 38% odds against the headline, you are looking at the price of the gap between what is being said and what is being done. And that price, that 18-point gap, it's the only number in this entire cycle that's been honest about the timeline.
18 points, Amara. That is not noise. That's institutional capital making a very positioned read on whether the apparatus can actually convert paper to kinetic action in the window that's remaining. The capital is saying, probably not. And the capital is also saying, we have watched this pattern enough times now to actually size the position. It's like they've seen this movie before, multiple times.
They really have, haven't they? And it makes you wonder. Now, descend with me for a moment, Mark. The same apparatus that has not filed against Colorado, it's also the same one that has not enacted the credit card rate cap that was proposed back in January. And the same apparatus rescinded the CFPB late fee cap last year. United States credit card balances, Marcus, they reached $1.277 trillion at the end of last quarter. They crossed $1.3 trillion early this year. Average APR on cards accruing interest, 21.5%. Average APR on new offers, 23.75%. And 90-day credit card delinquency, 12.7%, about 1 point off the post-Great Recession peak. Bankrate's report from January found that 33% of credit card debt was being cited as funding day-to-day expenses, groceries, childcare, utilities, survival expenditure financed at 21 to 23%. It's brutal, isn't it?
Wow. I mean, Amara, that is not a separate story. Not at all.
It is not a separate story, Mark. The reserve is general, The same posture that holds the CAS evaluation in a drawer, it holds the rate cap unenacted and the late fee cap rescinded. The same household that pays that absolutely staggering APR on their statement, they're also watching the announcement of the cap on the news. And the watching, it does not change the APR, does it?
No, it doesn't. And here's what compounds everything. Each executive order issued and then, under-executed without public consequence, it really shifts the implicit price of issuance downward at the next round. Capital, it prices it directly. That's exactly what the 18-point gap on WHAIEO is, right? Households, though, they price it indirectly through that gap between the announced cap and the actual binding number on their statement. Within 12 to 18 months of this pattern continuing, Amara, the question on the news desk shifts from, will the administration act on this, to, is there any reason to even cover the issuance at all? That shift, when it lands across the credentialed press at the same time as capital prices it the same way, that's when announcements really start to function the way the rate cap proposal functions now, as rhetoric, measured against the actual receipt. The Colorado effective date on June 30, that's the visible test.
Yes, the visible test. I like that. So whether the federal apparatus produces binding action before that date, it determines whether the next 12 months teach capital and households that paper authority is convertible to action, or that it is, by default, not. It's the training, isn't it? The training that follows. That's the harder return. And the body delivering that training, right now, is the body holding the authority in reserve.
Absolutely. It's a powerful lesson being taught.
So what we're watching for then is the moment one of those full missed deadlines, Marcus, actually becomes a file document. Or, and what is more likely on the current evidence, the moment June 30 arrives without it. That's not waiting passively, you know. The watching itself, that's what gets returned to you the next time the cycle issues the next framework. Howard Lutnick, he has a document on his desk that has not been published since March 11. The day it appears, or the day June 30 passes without it, that's the day the question stops being abstract. That's the calendar you are watching now.
My dear listeners, before we continue, a heartfelt thank you for tuning in. Your curiosity is invaluable. Please show your support. A like, comment, subscribe, or best of all, a share. It helps us grow and ensures more eyes are on that calendar, watching with us.
Absolutely, Amara. This discussion on policy versus reality demands attention. Your engagement amplifies critical, often overlooked distinctions.
Exactly. If June 30 passes without action, if paper authority remains just that, paper, the lesson learned isn't only about AI or credit cards, it's about governance itself. The market, as you noted, already prices in that skepticism. It's a significant cost to lose that faith. Wouldn't you agree?
Indeed. This loss of faith extends beyond specific policies. It creates an environment where announcements lose credibility, eroding public trust.
An erosion, yes. The June 30 test isn't just for an AI law, it's a bellwether. We discover if words on the page still hold power, or if they've simply become background noise.